So friends, in a truly breathtaking abuse of power and abuse of office, the U.S. Attorney for the District of Columbia just told Georgetown University School of Law that it can't teach DEI, and that if it continues to do so, its students will be banned from being considered for internships or employment at the D.C. U.S. Attorney's Office. As I say, friends, this is a breathtaking abuse of prosecutorial power. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, my goodness, this guy, Ed Martin, the interim United States Attorney for the District of Columbia, just did something that represents what might be the most egregious abuse of prosecutorial power I ever saw in my 30 years as a prosecutor. Let's start with this headline in Reason magazine. U.S. Attorney threatens Georgetown Law for teaching DEI. And let's just go right to the letter that interim U.S. Attorney Ed Martin wrote to the Dean of Georgetown Law, William Traynor. Dear Sir, as United States Attorney for the District of Columbia, I receive requests for information and clarification. I take these requests seriously and act on them with letters like this one you are receiving. It has come to my attention, reliably, that Georgetown Law School continues to teach and promote DEI. This is unacceptable. Can I just pause there? You know what? Sport, what is or is not acceptable for institutions of higher learning, colleges, universities, law schools to teach is none of your damn business. As U.S. Attorney, as the top prosecutor in D.C., you get to investigate crime, if crime has been committed, and prosecute crime. You don't get to decide what is or is not acceptable for a law school to teach. My addition to Ed Martin's letter. The letter continues. I have begun an inquiry. In other words, I'm going to use the powers of the U.S. Attorney's Office to investigate you. I have begun an inquiry into this and would welcome your response to the following questions. First, have you eliminated all DEI from your school and its curriculum? Second, if DEI is found in your courses or teaching in any way, will you move swiftly to remove it? And now, friends, the letter gets even worse because he threatens to punish Georgetown Law students. At this time, you should know that no applicant for our Fellows Program, our summer internship, or employment in our office who is a student or affiliated with a law school or university that continues to teach and utilize DEI will be considered. I look forward to your cooperation with my letter of inquiry after request. Thank you in advance for your assistance. Please respond by Monday, February 24, 2025. Should you have any further questions regarding this matter, please do not hesitate to call my office or schedule a time to meet in person. All the best. Sincerely, Ed Martin. This, friends, is abuse of power, abuse of office, and prosecutorial misconduct. So what can be done about it? We're going to get to that in a minute. First, let's look at the reply from the Dean of Georgetown Law, William Traynor. This headline from the AP, Georgetown Law Dean rebuffs DEI warning from top federal prosecutor for D.C. And that article begins, Georgetown Law School's dean on Thursday rebuffed an unusual warning from the top federal prosecutor for Washington, D.C., that his office won't hire the private school's students if it doesn't eliminate diversity, equity, and inclusion programs. Dean William Traynor told acting U.S. Attorney Ed Martin that the First Amendment prohibits the government from dictating what Georgetown's faculty teach or how to teach it. Quote, given the First Amendment's protection of a university's freedom to determine its own curriculum and how to deliver it, the constitutional violation behind this threat is clear, as is the attack on the university's mission as a Jesuit and Catholic institution, Traynor wrote in a letter addressed to Martin. Traynor said, Georgetown was founded on the principle that serious and sustained discourse among people of different faiths, cultures, and beliefs promotes intellectual, ethical, and spiritual understanding. Your letter challenges Georgetown's ability to define our mission as an educational institution, he wrote. Traynor closed the letter by writing, we look forward to your confirming that any Georgetown-affiliated candidates for employment with your office will receive full and fair consideration. So friends, the question becomes, what can be done by Georgetown law about these unconstitutional threats in violation of the university's First Amendment rights to teach what and how it chooses to teach? What can be done about Ed Martin's abuse of power, abuse of office, and prosecutorial misconduct? So it's not easy to sue, to bring a civil suit against a government official or employee. And let me argue for a minute or two why I think that is generally a good thing. Let's assume that I'm an IRS agent and I'm looking at people's tax returns and I decide that somebody took a deduction they weren't entitled to take. And so I go about, in my responsibilities as an IRS auditor or reviewer, telling the taxpayer, look, this is not a valid deduction, so you can't take it and you have to pay more in taxes. If that American taxpayer could file a lawsuit against me, drag me into court, make me expend all kinds of funds defending myself for a decision I made that was squarely within the scope of my official governmental duties, that would be a bad thing, because then every aggrieved taxpayer or every aggrieved American who didn't like something that a government employee or official did could forever be dragging government officials and employees into court. So the law has developed this protection for government employees and officials called qualified immunity. I argue it makes some sense. Qualified immunity provides some protection for government officers, employees, officials, that if you're acting within the scope of your official governmental duties, you're doing the right thing, you're doing what you were hired to do on behalf of the American people, you can't be sued. You can't be dragged into court. You can't be made to hire an attorney and expend all kinds of funds to try to defend against a suit that was brought because you were just doing your job, your official governmental duties. However, you probably know where I'm going, friends. If you do something as a government employee, officer, or official that is not within the scope of your official duties, that is outside the authority, the power of one's prosecutorial duties, like threatening a university that we're going to investigate you if you teach something I don't like, DEI, and we're going to ban all Georgetown law students from even being considered for employment in an agency of the federal government if you keep teaching something that I don't want you to be teaching. Whew. I mean, beyond a Saturday Night Live skit there, right? Well, guess what? That should not enjoy qualified immunity from being sued personally, because you're acting beyond, outside the scope of your official governmental duties. So I can only anticipate that Georgetown law, which probably has a heck of a lot of lawyers who are either on the faculty, on their legal staff, and goodness knows Georgetown law has produced a whole lot of really accomplished lawyers who are looking at the prospects of bringing a civil suit for this horrifically abusive act by a government official. And the only way to deal with this kind of rampant governmental abuse is to get it into court right now, early and often, and let judges put eyeballs on that letter that Ed Martin wrote. Man, I have got to believe qualified immunity will fall so fast it'll make Ed Martin's head spin, and he will run the risk of being held personally liable. That means he would have to personally pay out any judgment that was entered against him for what he did, abusing his position, his power, his authority, and engaging in this kind of prosecutorial misconduct. And any government official, Ed Martin or any other government official who abuses their power and position in this way should be held personally accountable. That's not why we hire people to work in the federal government, to abuse their office, to act outside the scope of their official governmental duties. So they should be held accountable for these kind of egregious transgressions. Because justice matters. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.